Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to come before this court will draw near to give their attendance, and they shall be heard.
Good morning. Please be seated. Our first case for oral argument this morning is 494 People versus Wendy Bummer Smith. Wait just a minute. We gotta wait. I probably could finish my thoughts, but we gotta wait till. Okay, go ahead.
Good morning, Your Honors. May it please the court, Susan Hutchison for the appellant Wendy Bummer Smythe. This voluminous record on appeal is permeated by Wendy's fear of her then husband, Frank.
We know all the facts.
Okay. But it was that fear that informed her decision to make the phone call, to call her friend.
We had one question, and that happens to be, was she alone in a room when she made that phone call, or was her oppressor standing there with her?
Your Honor, I don't
figure that out from the record.
I agree. I don't think it is clear from the record whether Frank was in the room with her or not.
If he wasn't, you would agree it would be very easy for her to say, gee, I spoke to him and, he's on to us. He knows that he testified against us. He doesn't want to meet us. He doesn't want to go to the mall. She could have very easily said that, whether she made the call or not.
Respectfully, Your Honor, I think given his coercive control over her, his psychological battering, his threats to kill her and her son, I think she acted under duress and under a motive of self-preservation and in fear of her life. This is a man who beat her, handcuffed her to her bed, broke her jaw.
We understand all that.
Okay.
So perhaps she wouldn't have even thought of it. She would have even contemplated the notion of not telling him exactly what happened.
Exactly, Your Honor.
I understand.
And I believe that the trial court got it right when it found that there was ample evidence of both abuse and her fear. I believe that in terms of the court's decision, attributing it to perhaps drug and alcohol use, I think that there is guidance from People v. Brenda WW in terms of if a domestic victim is also a drug or alcohol abuser, that alone is not sufficient to negate the significant contributing factor of the domestic violence.
So, Counselor, she has already served her sentence, though, correct?
That's correct.
She's on parole supervision. And what you're trying to accomplish here is to get her released from parole supervision.
Absolutely, that is correct, Your Honor. She's on lifetime supervision. She was released in 2020. She has had no violations, no criminal charges. She's 57 years old. She's in very, very poor health. My understanding is that she's in and out of the hospital frequently with various health conditions, COPD, a heart condition, and other ailments. And as the Court of Appeals has said, post-release supervision is an onerous burden. And I would ask this court to resentence her to time served in the interest of justice.
With respect to that second factor, the significant contributing factor, and we have some guidance. I know that you cited Judge Tertullio's decision in People v. Smith. There's certainly a temporal element. Is the domestic violence happening during the time that the events are occurring? And here we have that. But I noticed in Judge Tertullio's decision that there was a footnote where she talked about experts. And she said, well, in this case, in Smith, and I would argue Smith is certainly different than the facts here. But she even in Smith, she said, gee, an expert would have been really helpful here. And it seems to me that maybe it would have been more than helpful in this case, perhaps critical in this case. Can you comment on that at all?
Yes, Your Honor. We did have Jessica George, who was a trauma counselor, and she did testify at the resentencing hearing. And she had worked with Wendy since 2016. She, in my opinion, is an expert on trauma and gave her informed decision that Wendy was a victim of domestic violence and had suffered severe trauma, and not just from Frank, but also from her very traumatic childhood. So
Do you feel that she made the connection, that it was a significant contributing factor, that she was able to do that, or no?
yes, Your Honor. Absolutely, she made the connection because she testified that Wendy acted without agency and that Frank totally eroded her sense of self and her sense of personhood, and she was basically under his dominion and control.
Thank you.
Thank you.
Go ahead.
Good morning, Your Honors. May it please the court, Harmony Healy on behalf of the people. I don't know the answer to whether or not she was in the room alone with him. I tried to just quickly scan through the trial transcript. I do know in the trial transcript, she was pretty unequivocal that she was calling him of her own accord to go to the mall because she wanted to go to the mall with him. Frank didn't like to go to the mall. That's why she wanted to go. She wanted to play video games. And so it doesn't appear from the trial transcript that she had any influence by Frank at that time. She indicated that she was doing that of her own accord, and she never changed that throughout the trial. I think that with respect to the significant contributing factor, I don't think that there is a link, and I think that the hearing court did get it right. I think that the only link that we have are defendant's statements, and I understand that there have been quite a lot of statements that she has made throughout the course of this case from the 1989 to 91 time period, and including her parole hearings, her parole transcripts, and her statements that were made to George. But they were incredibly inconsistent. They demonstrated manipulation on her behalf of attempting to sort of guide the way that things were coming out in accordance with what she was aiming to get. And so I don't think that the significant contributing factor was established here. I also would note that I understand that George is a trauma counselor, but I don't know that she has necessarily the degree of training that an expert testimony would have, being a psychiatrist or a psychologist or a criminally forensic psychologist. I think that probably would have been helpful here, and we don't have that here.
Okay. I understand that.
Okay, thank you. And then just with respect to this court, I think also needs to consider the nature and the circumstances of the crime, and the hearing court needs to consider that as well. And the nature and the circumstances of the crime were horrific. And I think that when you're talking about releasing an individual to the community without any supervision whatsoever, that you need to look to the character and condition of the defendant, and that is clear from the statute. I think that the fact that there were so many parole violations that even the commissioner had said, I've never seen so many, I'm sorry, not parole violations, docs violations, that the commissioner said, I've never seen this many violations in my career, I don't think, and you continuously are accruing them despite the fact that you know that you're coming here and you're going to have to talk about it. I think that evidence is that it's not going to be safe to release the defendant to society with no release whatsoever, with no supervision.
Thank you.
Thank you.
495 through 496, People versus Ashton. Morning.
Good morning, Your Honor. May it please the court. The court below failed to comply with its obligation to conduct an inquiry when it became apparent both to defense counsel and the court that one of the jurors had been sleeping during portions of the readback of 3 of the witnesses' testimony.
Okay, counsel, I'll just stop you right here. Okay, so he fell asleep during, or she fell asleep during the readback. There's nothing suggesting that she wasn't paying attention during the actual trial. Is that a distinction that we could draw, that it's not necessarily critical that she be awake while the readback is going on?
Respectfully, Your Honor, and that's the distinction which the court below made, saying twice, well, it's not during trial, it's only during readback. The Court of Appeals has held that readbacks of testimony pursuant to a request by the jury is a material stage of trial. It's People versus Mametti. This court in People versus Russo came up twice, recognized this as a material stage of trial. The Court of Appeals in Pena held that the reason you have rebacks is that the jury is either uncertain as to trial testimony or there's a disagreement between the jurors with respect to the testimony. A juror who's sleeping during this material stage of trial is unable to then post-reback meaningfully participate in the discussions as to what the rest of the jurors heard during the readback. Furthermore, if other jurors noticed this juror who was sleeping, apparently for up to 40 minutes during the readbacks, that juror would not be able to persuasively participate in the discussion. In effect, instead of having 12 jurors, we reduced to 11 jurors. There's the attempt by the trial court to say, and he said it twice, that she's not disqualified because this is not during trial, it's only during readback. I'm not conducting the inquiry I would make if it was during trial, it's only during readback. That is a legally incorrect distinction. That would render the deliberative process, which is the most important part of a trial, which is the process by which the 12 jurors reach a verdict, insignificant. And that's the opposite of the case law. I call the court's attention, People versus Frankie, a sort of related case where in Frankie cited both in the appellant's brief and the DA's brief, jurors brought to the court's attention during deliberations, one of the jurors apparently was sleeping, and the First Department held it was a reversible error not to conduct an inquiry there, even though that juror had heard all the testimony, and the trial court said it was alert during the instructions because participation during deliberations is so critical. To set up a new rule with no case law supporting it, that it's okay for jurors to be asleep during readback testimony would be to basically obviate the most critical stage of a trial.
Okay, we'll look into that very carefully. Do you have any other arguments?
Oh, yeah, I'm just getting started, Your Honor. Because in this case, not only was there no inquiry, and the court resorted to speculation saying, well, it didn't appear to be REM sleep. I noticed the person's juror dropping a head, but not REM sleep. The Court of Appeals held in People versus Cargill that quote, a trial court may not speculate, but rather must conduct a probing and tactful inquiry. There was no inquiry here. The one thing that perhaps distinguishes this case, going back to Justice Bannister's question, there is a potential difference between sleeping during live testimony and sleeping during readback. During live testimony, the reason if it's determined that a juror was asleep, that juror has to be disqualified, is you cannot recreate the demeanor of that witness by rereading the testimony. But with jury readbacks, we're not concerned about demeanor. So if the court wanted to, could have simply asked for the court reporter to again reread the readback, and that problem would have been solved. This was an easy thing to do. This court.
Okay, wait, Mr. Schiffman, we have that argument. Do you have any other arguments?
Yep. The district attorney urges that this issue was not preserved. Yet in response to the counsel bringing the sleeping juror to the court's attention, the court interrupted counsel, ruled that I'm not going to conduct an inquiry because it's not during trial, twice ruled that the juror was not disqualified because it was not during trial. The court noted counsel's exception. Counsel then took exception. Thus, pursuant to CPL 47005 subdivision 2, the court below expressly having considered this, the very claim I'm raising now on appeal, and exception being taken, this issue was preserved and reversal is required. With respect to point 2 of Appellant's brief, we urge it was reversible error for the people's expert on child sex abuse accommodation syndrome to testify in detail about grooming and for the prosecutor to then use that testimony in summation as proof of guilt. In part, the people's expert testified how grooming could occur in front of other adults, how principals are taught how to engage children to get them to comply, how children are trained to do what principals want, and how offenders can groom the adults in the environment.
Counsel, I mean, courts regularly admit this kind of evidence, and appellate divisions regularly say it's okay.
Respectfully, none of that evidence is regularly admitted. It's regularly admissible to have experts testify about the components of child sex abuse accommodation syndrome. None of that, which I just described, are elements of child sex abuse accommodation syndrome. Testifying how parents and adults could be groomed, how grooming works with principals, that is not part of what's acceptable. To the contrary, in People versus Ruiz, this court held it was reversible error, even absent objection, to allow testimony about grooming. What made it even worse in this case is the DA in summation says it's grooming, it reads it like a playbook, he groomed them, he groomed the parents. Again, not only does it not fit within the elements of CSAAS, but rather it tracks exactly the allegations in this case, the very thing that is not permitted. So respectfully, what happened here was the very thing that this court held cannot occur. And I should
Okay,
point
we'll
out,
look at that, Mr. Schiffman. Do you have anything else?
well, finally, on that point, the people urge that this case is similar to People versus Lathrop, not People versus Ruiz. This is real simple. In Ruiz, the court dealt with testimony about grooming and use of grooming and held it was improper and reversible error. In Lathrop, there was no testimony about grooming. There was nothing about grooming being used, and therefore Lathrop is not the controlling case. Ruiz is. On that, I just want to brief on the other points, Your Honor. Thank you.
Thank you.
Good morning, Your Honors. Marty McCarthy for the People. Starting with the juror issue, that issue wasn't preserved, and part of the issue is in terms of giving the trial court gave the defense attorney an exception, if you will, but the defense attorney didn't indicate what was inadequate in that scenario, either the failure to conduct a sufficient inquiry or the failure of the court to excuse the juror.
But let's say we were to agree that it was preserved.
Okay.
Why don't you address it then?
I'm assuming that you would do that to me, so I'm ready for you. Assuming that you were to find that this was preserved. This was not, so when you look at all the other cases that relate to sleeping jurors, none that I've found relate to a sleeping juror who the allegation was only sleeping during readback. The case that Mr. Schiffrin referred to, an argument, the facts of that case were broader than as described, because it wasn't just that the juror was sleeping during the readback, they were also sleeping during the trial.
Right.
And everyone observed the juror sleeping during the trial and during readback.
And there's different consequences, isn't there? If a juror sleeps during a trial, we still have alternates. It's critical though during the stage that the jury has the case that we try to preserve that jury when possible, because there's no alternatives.
Yeah, and in this scenario, the alternates had just been excused.
Right.
They had been excused, and they had been there actually during deliberations, and they had just been excused when this thing occurred. So they were gone. But I don't want to say, I don't want to belabor the preservation point, but in terms of the inquiry that should have occurred, defense counsel didn't say anything. He didn't say, we should ask the juror how long they've been sleeping, what they heard, what they didn't hear. None of that happened. So we can't sit here and sort of evaluate what the court should have or should not have done under those circumstances, because defense counsel didn't make the record required to do so. And the other thing defense counsel didn't ask for was to excuse that juror. But ultimately, the sleeping juror didn't sleep during all the other stages. Defense counsel refers to material stages, material for the defendant, yes. But with respect to a juror, I did not come across a case where the issue was solely a juror sleeping during a readback, which is not evidence. It's not deliberations, because the jury can't deliberate there.
Why don't you go to the second point?
The second point, which is, oh my God, I'm drawing a blank.
Grooming.
I'm sorry?
The grooming issue.
The grooming issue. Sorry. Yes. So the grooming issue. So when Lathrop was a case that arose out of Monroe County, and Lathrop involved this particular expert. In my recollection of the facts of Lathrop there was an allegation that testimony was grooming, that the expert testified to what the defendant refers to here as grooming behavior. But what grooming, that the sin of Ruiz is where an expert tries to tailor their testimony to match the facts of the case, which is not what occurred here. So the expert did not testify to specific incidents, in essence, to tailor the testimony to say that this particular defendant was grooming these individuals. He testified generally about grooming behavior. I believe that testimony fit squarely within what the court found was acceptable in Lathrop. And it's important to remember Lathrop did distinguish Ruiz. In Ruiz, what had happened was that expert specifically tried to tailor their testimony to match the specific instance at trial. That didn't occur here, and that's why there was no error with respect to the expert's testimony.
Thank you.
Thank you.
497 People versus Lawrence Baker. Mr. Schifrin's still here.
Can't get rid of me so easy. Thank you. Good morning. Consistent with the holding of the Court of Appeals in People versus Bay, reversal and dismissal are required here, where the people never set forth any efforts to obtain the forensic test results or the disciplinary records of 9 police officers, both routinely produced materials until after 30-30 time had run. Importantly, the
Mr. Schifrin, though, didn't the prosecution turn over abundance of information initially when the first certificate of compliance was reported or filed?
They did, but the problem is they turned over a large volume of material, but they did something wrong with that initial certificate of compliance, which caused the problem. The statute requires a certificate of compliance to identify the items that were disclosed. They did not. They violated that provision 245.50. As a result, the prosecutor and the defense was unaware of the fact that whole categories of commonly produced materials, disciplinary records, and forensic reports were not produced. The Court of Appeals in Bay lists among the factors, voluminous materials can't excuse a failure to make any efforts with respect to whole categories of information. This is a case, again, where when the court asked the DA, what efforts did you make to obtain these materials? The answer was, I really don't have any explanation. That's the district attorney. The Court of Appeals in Bay said, look, 3 factors. The efforts made by the prosecutor's office to comply with statutory requirements with respect to these categories in 245.20, none were alleged. Next thing on the Bay, how obvious the missing materials would have been to a prosecutor exercising due diligence. It would have been really obvious if there was a listing as required by statute of categories that were provided, because there would have been a gap for disciplinary records. There would have been a gap in the listing for forensic test results. And
Mr. Schifrin, also in relationship to some of these documentation, there was a 7/10/30 notice, wasn't there?
Yes, there was, Your Honor.
And didn't identify body worn camera?
And that goes to the body worn camera issue. I'm focusing it both in my brief and during my argument today on the forensic test reports and on the disciplinary records. So, and there's a reason I'm distinguishing that with respect to
the forensic, excuse me, but the forensic report, wasn't that dated before the initial arrest?
The initial arrest, no, it was dated after
in January. I thought it was January 14th. It was there in January. It was dated.
The report was dated March 7th, Your Honor. The forensic reports were dated March 7th and were not provided until September 28th. Okay.
Right. But they were available much sooner than that. I mean, and
available to whom, Your Honor? Not available to the defendant. They were available to
Wait,
right.
just a minute,
And there were exculpatory information on that, right?
Absolutely. And
isn't that a Brady issue? Right.
There probably was a Brady issue also. Yes, Your Honor. And one of the things about 245, it basically helps identify Brady problems. There was exculpatory information because the forensic reports did not show the photographs that the complainant alleged were there. But they were not only were they not provided, the supplemental certificates of compliance never set forth any efforts, any explanations as for late filing as required by statute. Didn't identify what was or wasn't provided. And then in court, again, when asked why was this not provided earlier, the DA said, I have no explanation. He
did have an explanation, didn't he? Didn't he claim it was a minor oversight?
That's not an explanation. That's trying to minimize the result. That's
an explanation, right?
Yeah. If that's a satisfactory explanation, I think we have a problem with the statute. Importantly, the argument by the DA here and the holding of the court below was that these were inadvertent mistakes. Minor wouldn't impact anything, and the materials were disclosed as soon as the DA realized it. Those were the exact arguments made by the prosecutor in Bay, made by the lower court in Bay, which the Court of Appeal held to be reversible error. The Court of Appeals reversed that because the Court of Appeals held good faith is not sufficient. You have to show reasonable efforts to obtain not just some materials, not a lot of materials, but you have to look for all the materials. And given multiple opportunities to do this, not just in the initial certificate of compliance.
We understand on that.
And a court never done. No explanation, no efforts. That cannot be required reasonable inquiry when there was no inquiry ever asserted until after 30-30 time. For that reason, we urge there was a violation. two quick things before I stop, Your Honor. The DA makes two other arguments. One, the DA argues that there was a failure on the part of the defendant to timely notify the people of these discovery problems. There were multiple problems with this argument. First of all, this argument, this contention was not raised below and was not the basis of the decision of the lower court. Therefore, under Concepcion and LaFontaine, this court does not have the power to base a reversal on that argument. In any event, the reason we're in this situation, as I mentioned earlier, is because of the failure of the original COC to identify the items that were listed. If the district attorney had complied with that statutory requirement, it would have been obvious both to the DA and to defense counsel, the whole categories were missing. So basically, we have two separate problems with the COC here, rendering it improper. One, the materials were not provided, and two, there was a failure to comply with the express requirement of the statute to itemize items. The DA is trying to take advantage of their failure to itemize items and place the blame on the defendant for not knowing what wasn't itemized.
Okay, we understand that argument.
And the final argument that the people make is that somehow that the right to appeal from the order denying a motion to dismiss for violation of 3030 was forfeited despite the express language in CPL 3030 subdivision 6, which was adopted in the same statute which enacted 245, providing that claims based on orders denying motions to dismiss pursuant to 3030 violations shall be reviewable after a guilty plea. 3030 subdivision 6 does not make any exceptions for when the 3030 violation is based on failures to file a proper COC. None of the cases cited by the people in support of their forfeiture argument involve orders from a denial of a 3030 motion. They involve orders and issues with respect to discovery. But discovery violations, discovery orders, like most statutes, are forfeited. But we have as there is with 71030, and there's a separate statute here now, 3036, expressly stating otherwise. Thus, this court and other courts have repeatedly considered appeals from denial of 3030 orders after where the issue in contention was whether or not 245 was violated. I note, I bring to court's attention both People versus Gaskin and People versus Gear decisions of this court, and all members of this current panel, except for Justice Bannister, sat on either the Gaskin or Gear case, where the court considered the issue on the merits because under 3036, there's no forfeiture applicable. So that argument is simply without any merit. For all these reasons, we urge reversal of Mr. Baker's conviction. Thank you, Your Honor.
Mr. Strickland, let me ask one last question. You're talking about 3030 motions. I didn't see in the record at all that the court below made any calculations of time with respect to whether or not 3030 time had expired.
The court did, Your Honor. The court found there was only 30 days of excludable time. The 3030 time would have run by September 1st, but found that because as Justice Ventura pointed out, it was only a minor defect and not purposeful, that he found good faith and due diligence, and therefore found that there was not a 3030 violation, but there was a finding that there were only 30 days of excludable time, and therefore September 1st was the date where people had to be ready. The disciplinary records and the forensic reports were not provided until September 28th, obviously almost a month after 3030 time had expired. Unless there are any other questions, thank you.
Good morning. It would be easy to say that the record was perfect here, but it's not. And as prosecutors with the decision in Bay, it has made it easier for me as the appellate attorney in the office to direct and guide the attorneys. Part of the record here is not contained, and perhaps part of this would be to ask that it be sent back to expand the record to explain what was going on in the DA's office at the time. I was hired about that time, and this is not part of the record, but as part to explain what the circumstances were. The trial court judge is perhaps in the best position to decide whether there was good faith and due diligence.
But the reasonable excuse was with respect to, it's a minor oversight with respect to the forensic and the other 9 disciplinary records not being turned over. I mean, so how is that a reasonable exercise of due diligence or an explanation of why this information wasn't provided initially?
Those are the words used by that prosecutor, Judge.
A number of times.
Those were not the words that I would use.
Well, I mean, again, you're not, okay, I can't expand the record now
Correct.
to substitute your argument for the,
But to look at what actually happened here, the district attorney himself was prosecuting the matter. It was then taken over by the prosecutor, Dave Dyes, who's the one who answered the motion. If you look at the facts of the case, after he got the motion, he sat down with the investigator and determined that certain things were missing.
so the district attorney himself or herself was responsible for the initial certificate of compliance. It didn't list of all the items that were included.
The initial case was handled by another district attorney, assistant DA, who left the office. The district attorney, in seeking to assist with covering cases, took over the matter. And when Dave Dyes came in, he then took over the matter. It's hard
He
to,
found it within a day or two that the information wasn't supplied.
pardon me?
He found it within a day or two that the information was not supplied and then turned over.
Correct, but this goes to the point in Cooperman and other cases which have happened later on to show that there was it was in good faith. The district attorney, once informed, did sit down with the investigator. And looking at due diligence and good faith, it's hard to explain on this record, and I realize that, but for every case, every sex abuse case, every body worn camera, we're talking about hours and hours of footage that the district attorney assigned to the DA would have to watch.
So going forward, then an explanation of a minor oversight is going to be something that's acceptable.
No, I don't think
Just like
so.
the last case where we argued that a sleeping juror and during a readback would be okay. Now.
I don't think so at all, Judge. Realize this answer was written before Bay, not that the law wasn't clear, but to some, perhaps it wasn't. The use of those words is unfortunate. When you look at the actual facts of this case, with the district attorney himself reaching out initially in August 11th of 2022 to find out if the discovery was okay, the defense attorney just responded, I believe it's okay, I can access it. It was never reviewed. Now, remember, at this point now, 24550 has been enacted. All she said.
As Mr. Suffren indicated, that your argument you're making now wasn't preserved.
Well, 24550 was recently enacted and did apply at that time, not preserved, but still the law, Judge.
How can you argue here that it wasn't preserved below?
Because the law requires it.
Okay, I think we understand.
Thank you. Nothing else, I'm assuming. Thank you for your time.
498, People versus Motel. Model, I'm not sure how to pronounce it. I was correct? Why, thank you.
You're always.
You just want to know.
Is Amy here?
Okay, we're set.
Good morning. John Sarando for the appellant who was here with me in court this morning. This is an appeal from a conviction for sex crimes while the victim, I think there was a 2-year age difference. Number one, the waiver of appeal was invalid. The court said no further appeals. You can't appeal unless I make a legal mistake, which we know is not true. The guilty plea has a problem because restitution was added after he pled guilty. It wasn't included in the plea bargain. It wasn't included in the sentence agreement and acknowledgement. Counsel even objected to it. Austin and Hernandez say, okay, let's vacate the sentence and remit it to county court to impose the sentence promised or to let him withdraw his plea. We got a problem with that because the restitution was paid on page 208 of the record. So the money has to be returned by the victim, I guess, to place the defendant in the proper position. And we submit it's not up to the defendant to get it back. So I guess that's county court's problem to sort out. The defendant was denied youthful offender treatment. The court indicated the seriousness of the crimes, the prior acts of violence, and a lack of cooperation with the authorities were the main reasons that it denied that. In regard to seriousness, the defendant acknowledged his responsibility and acknowledged his wrongdoing and took responsibility. This, as I indicated earlier, was a boyfriend-girlfriend situation with 2 years of age difference. He did not plead guilty to the other claimed acts of violence. And the other thing, Your Honor, which is very surprising, is a claim of a lack of cooperation with the authorities. The defendant spoke with the police, and the only lack of cooperation there seems to be that he asked for a lawyer to be present. And I don't think someone should be penalized for invoking their right to counsel. Obviously, he pled guilty and he apologized and accepted responsibility. And I think it's a very good statement on pages 187 and 188 of the record. The sentencing memorandum, which I'm sure the court is familiar with, I just like to highlight a few of the things that the defendant was engaged in. He was a high school graduate. He was a member of the choir, a member of the student council. He was on the track team. He represented the students as a student body to interview the new school superintendent. A teacher was unable to write a character reference because school policy prohibited it. He worked part-time in maintenance while he was in high school as a janitor. He was at Boys State in the leadership program. He came home as a judge and a fire chief. He was a volunteer firefighter. He entered an early program in high school to allow him to get into the Marines as a gateway to college. He had finished basic training with the Marines, and with the non-YO, he's unable to be even a volunteer firefighter. He's unable to even try to get back into the military. So I think when you look at on balance everything, I think the court abused its discretion and in denying youthful offender treatment, and we would ask that that be reversed as you send it back for the other thing.
Thank you.
Thank you.
Go ahead.
Good morning, Your Honor. May it please the court. The issue of the youthful offender denial, I think, is probably the major issue here. And the people's position is that although the defendant and the victim in this case were close in age and appear to have been dating, it doesn't matter. He entered a guilty plea to forcible sexual conduct with this girl. And then he entered 2 more guilty pleas to rape third with lack of consent, not based on age, but based on actual lack of consent. And because of that, the nature and circumstances of this case weigh very heavily against the youthful offender adjudication, in spite of the things that he may have done in the past that were more positive. The crimes to which he pled are not affected by the age. And that would be the people's position in this case. Recognizing the fact that this court can change that determination without a finding of the lower court having erred, this court can do it in the interests of justice. The people's position is that the interests of justice require that this defendant not receive youthful offender adjudication, and that the crimes that he committed need to be dealt with as an adult. In regard to the restitution issue, obviously this is a collateral consequence, not a direct consequence. Does not require that the plea be vacated. I know in the past this court and other courts have remanded the matter to give him an opportunity to withdraw his plea if he doesn't accept the restitution. My argument in my brief, I would just briefly repeat, is that it is our position that the issue was addressed by the sentencing court. The sentencing court never said you have the right to withdraw your plea, but the sentencing court did say, do you want to be heard on restitution? There was an argument on restitution. Defense counsel never asked to withdraw the plea, never indicated that because of the restitution, they no longer wish to accept the plea agreement. Based on that, our position is that the defendant has accepted the imposition of restitution. If there was any argument at all, it was about the amount. And at most, I would say it would be remanded for a restitution hearing not an opportunity to withdraw the plea. And our position would be that that's not necessary because the restitution hearing could have also been requested at the time, and that was not done so, nor through any other post-sentencing motion. Unless there are other questions, I have nothing else.
Thank you.
Thank you.
499 and 504, Donna versus Theodore Flora the third.
Good morning, Your Honors.
Morning.
Great to be here. Winston Brownlow for the respondent mother in this case. Your Honor, the father's entire appeal is predicated on the fundamental misapprehension of the record. Family court never actually changed legal custody. The pre-existing order granted both parties joint legal custody in this matter. And the order appealed from here merely modified that order to grant primary physical custody to the mother. On the very last page of the record, it's very clear the mother's own attorney said that she is only seeking primary physical custody and joint legal custody.
We understand that.
So we would submit that all arguments based on the joint legal custody theory are academic and not properly before this court. The only other issue I would like to raise and submit for Your Honor's consideration is the father simply assumes that he has the right to effective assistance of counsel in this case, ordinary civil case between parents, no state involvement, not a TPR, no custody.
Do we need to reach that issue?
Yes, Your Honor, I believe you do. If there's no threshold entitlement to the effective assistance of counsel, then it would be academic to decide, it would be an advisory opinion to decide whether or not he was actually afforded effective assistance of counsel.
It would be improper for us to say, assuming arguendo.
That certainly has been done before, Your Honor.
Right.
I would submit, however, that the proper and best legal outcome here is to clarify, reaffirm this court's own decision in Harris. In Harris and in Lewis, this court has taken the position that I'm advancing here, which is that, there is no entitlement to effective assistance of counsel. Both of those cases did not address the merits. And we, would submit that there's no reason to do so if there's no substantive right.
Well, just in terms of the facts of this case, it seems that the argument as to why counsel was ineffective is sort of the way that he brought out this testimony. And it's a little bit confusing to me. And I thought from your brief that you may have agreed that it's a little bit confusing as well. What's the argument here? You shouldn't have raised it, or you should have raised it with respect to the gender issues potentially. It may not even exist, but potentially the gender issues of the child. So
sure.
So other than that, what are we talking about that might have been ineffective?
We're not. In fact, Your Honor, he concedes, father concedes the counsel was, quote, overall acceptable.
Right. So,
we've taken this case out of the general ineffectiveness and into the single issue. But again, that relates to the merits, in both in Harris and in Lewis. This court said there is no right to effective assistance of counsel. And in the absence of such a substantive right, there's no need to decide whether or not there was an effective assistance in this case. We would ask you to reaffirm those cases. Okay.
Thank you.
Thank you, Your Honor.
Giorgio.
Good morning, Peter DiGiorgio, attorney for the child. Basically, as submitted in my brief, there was a sound and substantial basis for the custody determination. And unless the court has questions, I'll rely on my brief.
Oh, I have one question. At trial, it appears that the AFC went the other way, sort of. What was advocating for the mother. And in this situation, you're the AFC and you're advocating for the father. And I just find that a little curious and want a little bit of an explanation about that.
Actually, you got it reversed, Judge. The trial FC was advocating for the father to have custody.
That's right. I'm sorry.
Advocating for the mother. As is required, I used substitute judgment after my interview with the child. He just turned 5. I did note that even though the trial AFC took a position adverse to the mother, there was no notice of appeal filed by the AFC. There was no stay that was requested or granted. So in weighing everything and using my substitute judgment, I found the mother to be a fit parent, and I found that several months or a year later, to disrupt the living arrangement that my client had been living under. He's already enrolled in kindergarten in North Harnell School District and had a routine. I determined on appeal that it's in his best, given that the mother was a fit custodial parent. And I think the trial court made a finding that she had been the primary caretaker and had met most of his needs, and that the father had some issues with co-parenting and would not promote, co-parenting. I felt on appeal, reading the record, I exercised my discretion to use substitute judgment and advance the position that I thought was best for this young man on appeal.
Right, and
Thank you.
you've had the benefit of the trial transcript to see what the testimony was at trial, which a prior AFC didn't have that because they were involved in the trial.
Correct. Reading the record, I mean, being an AFC on appeal is not an easy task because kids change their mind all the time. I've been AFCs at the trial level and advocating a higher position, and then by the time the appeal comes along, the child changes his position. And then, that makes it difficult to be a lawyer sometimes, but we navigate through it the best we can.
Thank you.
Thank you.
500 in the matter of Kevin V.
Good morning, Your Honors. Apparently, I'm the only person on.
You're solo today.
As attorney for young Kevin, I can report that he is doing well in his foster care placement. He's receiving special education services. And I would just rest on my brief unless the court has any questions.
Thank you.
Okay, thank you.
501 is in the matter of Janelle King versus Andrew Pelkey.
Morning. May it please the court. Thomas Babylon.
We just got it. Okay, there we go.
Ready?
Yes.
Okay. May it please the court. Thomas Babylon on behalf of Appellate Andrew Pelkey. First issue I'd like to discuss this morning is that the trial court's failure to allow discovery with regards to the mother's mental health records. In this particular case, Ms. King filed the petition for sole custody, which necessarily brought her mental health into issue. And it was necessary to have those records in order for the court to make a determination.
Is that true? That just because you ask for custody, does that bring your mental health and your past any possible treatment or counseling into issue?
Well, mental health of the parents is a factor that's required to be considered by the court. In this particular case, the mother acted erratically at a pickup. It was on video.
In your opinion?
I'm
Okay.
sorry?
In your opinion?
Well, in my opinion, yes. She also lied to police about the incident, lied to her care physician about the incident, lied to the court in an affidavit for a family offense, which she later withdrew. So she said things in those that were untrue, that she was assaulted. When in fact, she had showed up at a time where dad was supposed to pick up the kids, prevented him from accessing the children, standing in front of the door, screaming, alleging that an assault had occurred that had not occurred, pulling on the back of his shirt.
So you're saying that basically anytime there's a custody petition, mental health is at issue?
Well, yes, I do believe that, Your Honor. In this particular case, at the hearing, there was an admission by her trial counselor that she had been in mental health.
No, the admission was just some counseling.
Yes, that's correct.
Okay.
But isn't part of the problem it wasn't alleged in the petitions or in the motions?
I don't think that's a problem because when a party seeks sole custody, which is what the mother did in this case, she necessarily puts her mental health at issue. And other courts on this particular issue have said that they waive their privilege to those records when they do those things. And it's important in this trial. It actually came out that Ms. King admitted that she'd been in mental health for most of her adult life. And the father testified that she'd previously been on mental health medications, and two witnesses test about violent outbursts that she had in the past. So I think it was very important for the court to consider these records at that time. And I think it was error for the court not to allow the discovery. And if the court had concerns that the discovery was not relevant to the case, they could have simply allowed the discovery to come to the court and examined it in camera and made a decision at that point. But the court did not even do that.
Counsel, can you clarify just the timing of the events? It seems that it's not a request in the petition. It's not raised in the petition. We then have the request for the mental health records, and the court finds there's not a sufficient basis for it. Then we have the trial proceeds, and we have testimony about sort of the screaming and the overreacting, I'll say, certainly based on the father's mother's testimony, the paternal grandmother's testimony. Was the request ever renewed, saying, in light of now what we've seen and what we've heard, Your Honor, now we'd like the mental health records? I didn't see that request in the.
Well, the videos were available at the time the request was made, and they were referenced in the request.
The issue on the video was that she lied to police, that she says there's physical interaction. You would agree on that. She characterized it as an assault, but the reason why the mental health records were necessary as well, she lied to the police about the assault. And you read this, you watch the video, maybe it's a little bit muddled. But that was the only basis given, wasn't it?
Well, also, Your Honor, at the hearing, the AFC requested that the records be released because the children had made disturbing disclosures to her, and she felt that they needed to be released on that basis. That was the AFC's position at the hearing, and the court still denied them. So there was the actions at the daycare. There was the request by the AFC based on the statements, the disclosures that the children had given her. And there was the admission by her trial counsel that she was in mental health counseling. On that basis, I think that at least the court should have permitted an in-camera examination of the records. And then they could have made a determination whether or not they're relevant.
Your client never requested a Lincoln hearing with respect to the older child?
None of the parties requested a Lincoln hearing. So that they all did not want to put that on the children. So there was no Lincoln hearing requested. The other issue I'd like to discuss is with regards to the court failing to properly weigh or not considering factors that's required to consider in making a decision when it changes custody. In this particular case, the court they didn't consider Miss King's mental health at all. It was not addressed, even though Miss King admitted she'd been in mental health counseling for most of her adult life. There was testimony that she'd had violent outbursts.
Okay, again, you're repeating yourself, so.
Well, this is a different point, though, Your Honor. This is with regards to the court failing to consider that factor, which they did not mention whatsoever. Also, they failed to consider the prior custody agreement, which had been in effect for 5 years prior to this, and there had been no evidence whatsoever that it wasn't working properly. The only evidence was that the children had, for a short period of time, been a few minutes late for school on the Wednesday to Thursday overnight. So that was the only evidence that the prior, and that the case law says that the prior agreement is to be given great weight unless it's shown that it has been working. The other instance is the willingness of the parents, each parent, to foster a relationship with the other parent. The court did not consider. Here, Ms. King's actions at the daycare clearly show that she did not foster, and she withheld the children for 7 weeks. That was in the record also. So that should have been weighed in favor of the father, and it was not considered at all. And they also failed to consider that the need of the children to live with siblings. In this particular case, there was the children had a half sibling that lived with Mr. Pelkey. And the court, in my opinion, failed to properly weigh other factors.
Like the ones that weighed against your client.
Exactly, Your Honor. Specifically, the inability of the parents to co-parent. He improperly weighed that towards the mother when the AFC had advocated for sole legal guardianship to the father. And the evidence showed that the mother was unable to co-parent, and that's evident by what happened at the daycare. They also gave little weight to the recommendation of the AFC, no weight to that recommendation of the AFC whatsoever, where the AFC recommended sole legal custody to the father. They also improperly weighed Mr. Pelkey's lease of his home instead of owning a home when it had no impact whatsoever with regard to the stability of his household. I believe he lived there for 12 years or something at that time, or not 12 years, but a substantial amount of time. And they also improperly weighed the alleged domestic violence incident, which they said was not a domestic violence incident, but they still considered it. It was fully investigated by CPS and it came back as unfounded. And there was no Lincoln hearing, so the children didn't testify about it, and there was no corroboration of the one child statement.
Could the court below have been so incredibly upset with the idea that the father was driving around these children without a driver's license for so long, despite being arrested for not having a driver's license and continually ticketed for that? Do you think the court, so my question is, do you think that the court weighed that factor so heavily that the others sort of fell away?
I don't think so. If they did, that would be improper. Here in this particular case, the abstract is in the record. The father had 2 suspensions for failure to appear at a court. which I believe that he can no longer even be suspended for that, or actually, no, it was for failure, failure to appear, so he was suspended for that. And in opposition, the mother lied about a physical incident occurring. So that should have been weighed against her credibility.
Okay.
And with regards to the, just, I'd say, if there's any more questions, I'm sorry. I think I'm done. Thank you. Thank you.
Okay, go ahead.
Good morning, Your Honors. I am the AFC who was in the trial, and I think that part of the problem with this trial was it's so extended over such a long period of time with so many interruptions in the trial itself, that it was hard to keep consistency with these kids. They did change their minds at times, and it was hard to portray all of their interests during the trial because it changed. I was concerned with the mental health of the mother, but I thought it was very apparent during the trial how she presented herself and how she acted in the videos. I thought her mental health was very well observed by the trial court judge. I think her records, I didn't want her therapist and her relation to be interrupted. I know she was in continual treatment and that she was on medication. So I didn't want that to be interrupted, because if you do interrupt that, then that's a problem for the mother to reestablish, possibly with a new therapist. And that's the consistency was more important to me with her therapist. I did feel that
counsel,
I'm sorry.
With your respect to your recommendation, it seemed to me from the record that one of the bases that you gave, if not kind of a significant basis, was that it would then force the parties to communicate with each other.
Yes.
First of all, is that right? And second of all, is that one of the factors that the court should consider? Should the courts be trying to force parties that are having confrontational issues to be communicating with each other?
Yes, I think they should. I think that the parents need to learn to communicate. The more the parents can communicate, the better off these kids are going to be. If you have parents who are diverse and they're not communicating, as these kids grow older, they already know how to manipulate. They're only going to manipulate more. So if you force these parents to learn to communicate, even if it's by using apps, as we're using now, a lot of these courts are recommending that they use this Close app now, where the parents have to use it to communicate. It really does make a difference. And these kids are young enough that they are still impressionable. And I do believe that you do have to force parents to communicate. And that's one of the things that I found was egregious with this mother. She would make decisions, sole decisions, based on therapy, based on medical, based on school. She made the decisions for everything. Daycare, she did not communicate with the father. And I thought that was something that needed to be brought forth, that she needed to understand that she was not a single parent, that this father wanted to be involved.
There was some evidence that she regularly communicated the changes with the children's extracurricular activities with the father. Was that an exception as opposed to the rule?
I believe so. And I think that on the extracurriculars, they did work together. The oldest child played rugby, flag rugby, and they worked together. The father was the coach. The mother would transport the child. And there were other activities that the children did that they did communicate well on. But the issues of primary importance, education, therapy, all these primary decisions, the mother just excluded the father. And I thought that was wrong.
Counselor, when you started, you referred to the hearing being broken up by the hearing exam.
Yes, sir.
How could you explain that?
Our schedules are so bad. Right now, we have so few law guardians and so few court times available that trying to pick court dates, they got pushed out. We're in trouble. We have I think in Oswego County, we're down to 5 or 6 AFCs. Onondaga County is the same. So
okay, we don't have to go into all of that.
But did he do the trial one day after another, or was he adjourning it? How did
it was, we would pick a new court date at the time we were doing trial. We would pick the next court date, but it would be months out because of our schedules. We would not go day to day.
Okay.
Thank you. Thank you.
If there's any other questions. Thank your honors.
505. Oh, I'm sorry, 503, Savannah Fallon versus William Clark III. Okay.
Good morning, your honors. May it please the court. Stephanie DeGiorgio on behalf of the appellant. I'll keep it fairly brief and simple. Essentially, the alcohol problem and that he drank in excess. Otherwise, it made no mention of any other facts or findings. It was pretty conclusory. As such, I would submit for the court to remit the matter back to family court for specific findings in the best interest of the child. So that we can have clear appellate review as to what exactly the court utilized in making that determination.
And what are you specifically requesting today? Is he looking for more visitation, unsupervised visitation? Is that it? Or does he really want custody?
I'm not sure exactly what he's
document. If we agree with you on the release, how does the BCA allow for this remedy?
So the BCA, and this goes to, and it's we move for summary judgment on this point. And by the way, there are no issues of fact that North Ellicott has no ownership in the property, can't control the property, can't access the property, basically has no right to do anything with respect to this continuing development project. So under the DEC regs that we placed before the trial court, when a party to a BCA no longer can do anything with respect to the development, the DEC has the ability to actually terminate the entire agreement. So we took the step to prevent that, to move, and the DEC was obviously named in this lawsuit, and the DEC took no position, simply said, we'll do what the trial court said.
But the DEC could also remove an applicant. They just typically don't.
So they typically don't. And our communications with the DEC in advance were, well, if you guys take these steps, we'll honor whatever the trial court says. So we took these steps to ensure that this brownfield cleanup agreement stays in place and that this project can finally be finished. This Pilgrim Village project's been going on for a lot of years. And North Ellicott and its position, and this is in the record as the court knows, has taken steps as party to the BCA to stop work on the project. They've done things to, for example, they removed my clients from the brownfield cleanup agreement, which was illegal. We had to go through 2 lawsuits and an appeal on that. So there are a lot of issues here. So this is to ensure the project gets finished. And I think there are no issues of fact with respect to North Ellicott's complete inability to participate in any way in this project. There's no reason for them to be there. They have no benefit gained from being there. And the only reason they've stayed on is to be difficult. So it's time to hopefully close this whole thing out, get this project completed. Unless the court has any other questions.
Just did NEM already benefit from the brownfield tax credits? And therefore, if this ends up being terminated by the DEC, let's assume that there's a request made and they just say, we don't want this headache. We don't want the possibility of an Article 78 brought by the entity that we're removing, the applicant we're removing. Would NEM lose out on its tax credits? Would they have to pay them back? How does that work?
So no tax credits have been awarded on this project yet for start. So, but secondarily, to the extent North Ellicott has actually paid cash to do environmental cleanup, even if they're removed from the brownfield cleanup agreement, they still get to claim those tax credits. So there's no loss to North Ellicott, whether they're removed or not. So they're actually in the exact same position now that they'll be in if they're removed. And by the way, because they can't participate any further, there's no further money they're going to spend on cleanup. So whatever they've already spent, they're already going to receive that benefit.
Thank you.
Thank you.
506, Carl Clark versus City of Buffalo. Wait to say. Yes. We hope it's just a sec.
No problem. Fortunately, I wasn't the first one, so I saw how everybody else would jump ahead.
There you go. Okay.
Good morning, Your Honors. Today, please report. My name is Jeffrey Marion, and I represent Carl and Catherine Clark with respect to this matter. They are the appellants.
Okay, I'm going to interrupt you right up. This is a pretty narrow issue, as even though there's lots to say about it. It's whether or not this special duty exists. And you say it doesn't. Steadfastly have said it doesn't. That you only have to prove ordinary negligence and then you can recover. The city has asserted, and Supreme Court agreed with the city, that there is no special duty and thus you're out. You're the case dismissed, case over. So that's the issue, isn't it?
Well, I think it is an issue. I think it's also a smokescreen for the other issues that I have raised regarding spoliation and summary judgment. But on that issue, yes,
if we find no special duty, none of the rest of that matters. Spoliation, it doesn't matter because if we agree with the trial court, the case is over, regardless of what the other evidence is. Isn't that right?
Well, that would certainly be the case, and that would be if you were to uphold the decision of the trial court. I would also note for the panel that the recent decision, LG 70 Doe v. Town of Amherst, I think reiterates the position that there is no special duty of care here. There isn't any new ground broken in that case. It basically it doesn't add anything to it, and it's sort of the general overall duty. I think where that would apply in terms of garbage pickup is a public health and public safety issue. That's not the case here. Once that driver turned around, came back, couldn't operate his truck, enlisted the plaintiff's aid, and then dropped the can on him, then that's well beyond the special duty of care. That's well beyond any sort of overall duty here that we're talking about. It's a stretch, as I mentioned in my brief.
So you're asking us to sort of draw a line between garbage pickup, which would require a special duty, it's a governmental function, et cetera. You want us to draw that line between governmental duty being the garbage pickup and ordinary negligence, meaning those extracurricular acts of assisting the garbage men because the device didn't work, blah, blah, blah.
Well, there is a continuum, I think, in any given governmental case. We all would agree that there are situations where a governmental entity can be found to be ordinarily negligent and someone can recover. When you look at the overall, the governmental cases, you're looking at the overall, like Kircher versus City of Jamestown, Moldovan versus County of Erie. These are all the general principles. That's not this here. What you'd be looking at in terms of a special duty of care would be a situation where they just simply drove past and the garbage stayed out despite whatever efforts Mr. and Ms. Clark made to have it picked up, and they contracted a rodent-borne illness or were bitten by a rat or a raccoon that was in their garbage. That would fall into the special duty of care. Once this driver affirmatively turned around and then he said, "Hey, buddy, I can't operate this truck. I can't operate this scoop. Can you help me dump this manually?" The reliance is actually on the city employee at this point. The plaintiff hasn't relied on the city for anything else at that point. So once that, we have a continuum, and also my colleague would concede and has conceded on the record in this case that if this were a car accident, if the garbage truck had passed a stoplight or a stop sign and struck the Clark's vehicle, it's ordinary negligence all the live long day. So there's always a continuum. It's not as simple. I think the problem is that the trial court got a little wrapped around the axle of it being an absolute, and that's my concern here. It's not an absolute. It's a continuum.
Okay, you've made that point. We get that. So
Okay.
Look at that.
Before I forget to ask you, can you give me the citation? I didn't see the case you mentioned in your brief. LG 70, you said?
It is a brand new issued by the Fourth Department. It's as you can tell, I've been reading the website. It's CA 22-01514. I believe it came out in April or late March. So, but
Do you have anything further?
yeah, I mean, honestly, the spoliation and preclusion issue, at this point, I think assuming that the court finds that the special duty of care doesn't apply, there's no other relief at this point because everything that the plaintiff tried to do was frustrated. I mean, it cannot possibly be that that random people show up and go out and pick up garbage and the city cannot identify who they are, what truck, where they went, what the route was. This isn't willful and contumacious. I will concede that point. But as a government entity, once they're on notice, they have to start preserving this evidence. They have to preserve it under FOIL. And it's their obligation to have these very simple items. So we're flying blind, and I'm trying to preclude a trial where they all of a sudden walk up, say, "Hey, look, we found the guy." And he now testifies that Mr. Clark had the can over his head and tripped over and fell. So I'm trying to place him. But so I think once you get past this, then there's no other alternative but to turn this entire case around. Plus, there's been no medical examination. There's no evidence, nothing from the city that would
countermand the facts of this case that would say that there was no negligence. So I think at this point, they would be left obviously at damages with comparative fault, but anything else I think would have to be struck. I think they'd have to be precluded from offering any evidence. And I think the jury would have to be charged on the issue of spoliation
Okay,
here.
we'll look at that.
So that's all I wanted to say is that just in sum, this is I think the special duty of care doesn't apply. It's a smokescreen for the larger issue of the negligent spoliation of evidence. And if the court does not have any other questions, I will yield my time to my colleague, Mr. Quinn.
Thank you. Mr. Quinn?
Good morning, Your Honors. May it please the court. On that last issue first, the city at all points during this litigation has disputed that this incident occurred at all, let alone in the manner in which the plaintiff is occurring. It was not reported to the city on the date of the accident. The plaintiff did not seek medical treatment for over 30 days after the accident. The first the city ever heard of this was through the receipt of the notice of claim. So the court knew all of this, the trial court knew all of this, considered all of this, and issued a decision which was correct. And this court should affirm that should it be reached. It's an abuse of discretion standard. The court did not abuse its discretion in determining that dismissal of the city's answer or some type of finding against the city on those bases was proper, and that should be affirmed. On Justice Bannister's point, I do think you are correct that if the issue of special duty, and we're sort of confusing the way we describe it a little bit, but I think we're all on the same page. If the issue of special duty is found to be required and the plaintiff concedes at the trial court and in the brief and even today that they are not alleging a special duty, we believe that that is an essential failure in their proof, and the complaint should be dismissed on that grounds alone. But to get to sort of the merits of the issue, this is a special duty case. There is no question that the plaintiff has to prove a special duty to pursue this claim because garbage collection is a governmental function. We've cited cases from the Court of Appeals, the Second Circuit, the lower courts and trial courts, all establishing that fact. The plaintiff essentially is trying to argue that there should be some line drawn, but doesn't articulate where that line should be drawn, doesn't point to a case of where that line should be drawn, and does not articulate an argument as to why the line should be drawn to try to get around the simple fact that they have not alleged a special duty.
All right, well, counsel, my understanding of opposing counsel's argument this morning was the line that's drawn is when your garbage truck operator said, yeah, I'll come and get your garbage. And he turned around and went back. Okay, so now somehow this incident is taken out of the special duty situation and now is in the ordinary negligence situation, especially when the truck didn't work properly, as he alleges, and the driver needed help. Can you speak to that?
All of the facts of this case, and they are relatively unique facts, that's important because there is no proprietary private equivalent of this fact scenario. The only reason that the driver is there is because he's engaging in municipal waste collection. If you look at the plaintiff's notice of claim, specifically paragraph 4, he alleges negligent hiring and training, all related to the waste collection. He alleges a failure to pick up garbage in the course of traveling in violation of policy. That gets to the very requirements of the very governmental nature of what is happening here. This is not a motor vehicle accident. There is no private proprietary situation where an individual on the side of the street would flag someone down, say, come pick up my garbage, and have that person come to their house on their route and engage in municipal waste collection. Plaintiff's own sort of theories and motivations as to why he tracked them down gets to that governmental nature. He didn't want the garbage to be sitting there. The neighbors didn't want the garbage to be sitting there. The only reason the city goes back is because they are going to put away that garbage. They're going to take that garbage from the tote and take it to municipal waste collection places where it's going to be processed. So I do think you can't equivocate this to a car accident where someone is just driving along the street.
So let me ask you, counsel, let me ask you this question. Did your garbage truck driver ever cease being in the mode of garbage collection? Did his actions at some point change in nature?
What the case law says is that you sort of have to look to the specific acts alleged, the specific activity in which that person is engaging in. And in this case, he is specifically engaging in garbage collection. That is what
That doesn't change.
That doesn't change.
that doesn't change in the facts of this case. If you're
That's what I, where.
Yeah. If you're considering in the facts of this case, he is engaging in garbage collection at every relevant time. Now,
Okay, we understand that.
I do have other arguments that I think even if you do find a special duty or a question of fact that's a special duty, we would still be entitled to governmental immunity. That is a more difficult case for me, I will acknowledge, given the facts, but I would submit that even assuming the facts that the plaintiff is alleging in the light most favorable to them, this individual driver did sort of try to put the garbage away himself. He was unable to do that. He then used his discretion in trying to have the other individual help him. So he would be entitled to governmental immunity for that reason. So we would also argue that we're entitled to judgment as a matter of law on those grounds.
Thank you.
Thank you all.
507 PB 33 DOE versus Gregory Rudolph. Good timing. Go ahead.
Your Honor, may it please the court. Heather Deckard on behalf of the Village of Warsaw and Warsaw Police Department. There are very few facts relevant to the pending appeal. First, on March 20th, 2020, Governor Cuomo issued Executive Order 202.8, which told any specific time limit for the commencement, filing, or service of any legal action as prescribed by the procedural laws of the state. Second, on August 3rd, 2020, CPLR 214G was amended. That is the revival window for CVA claims, and it extended that window, explicitly stating that actions must be commenced not later than 2 years and 6 months after the effective date. It is undisputed that that date was August 14th, 2021. It is also undisputed that plaintiff did not file a complaint against the Village of Warsaw and the Warsaw Village Police Department until October 21st, 2021, more than 2 months after the revival window closed. Plaintiff has argued that his complaint was timely because the original tolling order 202.8 was continued by subsequent orders. However, Executive Order 202.8 issued in March of 2020 did not apply to CPLR 214G as amended because it had not yet been amended. It was not a law when the initial executive order was issued. As Executive Order 202.8 could not apply to the amended CPLR 214G, no subsequent order continuing that executive order could apply. Stated another way, CPLR 214G was not told by the subsequent executive orders because those orders merely continued the original tolling, which was not in place when the legislator explicitly extended the statute of limitations only until August 14th, 2021.
Go ahead, please.
Plaintiff points this court to decisions from 2 other departments. However, those cases do not require this court to hold that the explicit window provided by the legislature was extended by another 90 days by the executive orders. In Doe versus Archdiocese of New York, the first department looked at this issue, but relied on a case from the Court of Claims, matter of MC versus State of New York. Reliance on that case in relation to this case is misplaced. In the underlying case cited, the issue was whether the CVA case was timely served based on a Court of Claims service requirement. The case had been timely filed within the revival window, but it had not been served. The case was thus about service, and the court did hold that the tolling applied to the Court of Claims service rules. The second department case, which plaintiff submitted in their letter to the court, again, relied on that first department decision relating back to the Court of Claims case
and pointed to another Second Circuit or Second Department decision, McLaughlin versus Snowlift Inc. In that case, again, the issue was about an existing statute of limitations at the time the executive order was issued. It was about whether a personal injury subject to CPLR 214.5 and a 3-year statute of limitations was subjected to the tolling or not. Both.
We'll look at all those cases.
Thank
Do you
you.
have anything further?
Your Honor, what is more directly applicable is the Second Department case of Echeverria versus the Board of Elections of New York City, in which the Second Department held that the tolling in the executive orders did not apply to the issues in question because the legislator had specifically passed legislation addressing the date for filing petitions and subsequent election law Article 16 proceedings. That is the case most like ours, where after the original executive order, the legislature addressed the issue. The legislature gave them an additional year to file the CBA claims, during which plaintiff could have but did not file this claim.
Anything for that?
No. Thank you.
Go ahead.
Good morning, Your Honors. Ari Taub on behalf of the respondent, and may it please the court. Your Honors, every court to have addressed this precise and discrete question has ruled in favor of the respondent's interpretation in this case. The simple issue is whether or not Governor Cuomo's executive order that was issued starting in March and then sequentially thereafter every 30 days told the statute of limitations for pending statute of limitations during that time period. In this case, the August 3rd, 2020 amendment of the CBA was passed prior to 3 sequential executive orders that each told the statute of limitations for 30 days. In light of that, as every court to have addressed this issue has determined, not only is it a toll, as this court held in Steele case, but it is also a toll specifically for the CBA. In fact, the arguments that are addressed by my colleague on the other side relate to, for example, Echeverria, which is the one case that held that the executive orders weren't a toll. That case related to an election law matter, which was not an urgent, which was deemed emergent and therefore not subject to the tolling. And for obvious reasons, they needed to have those election processes done in time. The Appellate Division, First Department in Doe, and the Second Department in Bethea were not distinguishable. And the argument that they are distinguishable, that they were relying on matter of MC, which is a court of claims case, is simply inaccurate. I was the attorney who represented the plaintiff in matter of MC. I litigated that, I briefed that, and the court's decision is abundantly clear. The court's decision is specifically whether or not the executive orders by Governor Cuomo issued after August 3rd, 2020, told the CBA for the, quote, commencement of Child Victims Act cases. The court said it does. It's been approved by multiple different court of claims cases, multiple different Supreme Court cases, and the appellate divisions here. The point that I think my colleagues on the other side do not interpret correctly is that these executive orders are somehow all interspersed and all linked together, and therefore what didn't exist on March 20th when the first executive order was issued cannot be applied later because the statute was signed later. That's a fundamental misunderstanding of what the executive executive law 29A states. That law specifically states that a statute can an executive order tolling the statute of limitations cannot last for more than 30 days. And because of that, Governor Cuomo could have rewritten the original executive order or continued it and thereby interpreted therein all of the requirements of the statute for the reasons that matter of MC held, as well as Doe and Bethea, respondents submit that this court should affirm. Thank you, Your Honor.
Very much. 509, James L. versus Star Point Central School District.
Morning, Your Honors. Kevin Burke here for the appellants. I'll dive right in. This isn't challenging the decision of the school district about a disciplinary decision. This is about a very specific procedural point. This is about the emergency removal of 2 students without any process. Starpoint violated its own policy number 3421, which is the Title IX policy against sexual harassment and sex discrimination, specifically section 4C, which requires before an emergency removal, the school to perform an individualized safety and risk analysis to determine whether a respondent student is an immediate threat to the physical health or safety of any person arising from the allegations of sexual harassment.
And you contend your clients were not immediate threats because they weren't specifically involved in the activity. They were instead what were termed ringleaders as opposed to the ones who actually physically assaulted the victim.
That is part of the argument, Judge Nowak. However, the main thrust of our point is that the school district had to perform an individualized safety analysis regarding each of the 2 individual appellants. They did neither. They never presented any evidence to how either one of those 2 individuals posed an immediate threat to the safety and health of the complaining student.
They determined one was in in 4 classes, the other wasn't in any classes, correct?
That is correct. And this, in terms of the one student, this wrestling season was over, everything was finished. And to be clear, the Department of Education, look, section 3421, the policy mirrors the Code of Federal Regulations at 34 CFR 10644. The Department of Education has explained its rationale for why the words immediate threat of physical violence or physical harm is in the CFR. And the DOE was very specific, and we briefed that at page 8 and 9 of our memo. The final regulations make it clear that this removal isn't about discipline. It's not even about illegal conduct. It's about, is there an immediate threat of continued physical harm? And the record is devoid of any evidence of that. Sure, there are allegations that bad things happened to that student. There's no dispute about that. There is a dispute about who did what to whom, and the record is totally devoid of any claim that there was a threat of continued violence. If you look in the record, if you look in the complaint, even the worst parts of the complaint, nowhere does the complaining student say that he feels worried or threatened or scared that this will happen again. His mother didn't. There are larger arguments to be made in different courts, but this is about punishing 2 boys, not about protecting the one alleged victim. This was about taking the 2 boys out of those classes.
I think we have that argument.
Out of their activities. Okay, very good. So what we're talking about is a very technical point that no individualized safety risk analysis was performed, and it wasn't conveyed to us before the class or before they were removed from classes. Now, there's no dispute that something happened to this individual student. The dispute is, was it proper to remove the 2 appellant boys from all the classes and all the activities while that was going on? Now, what ended up...
Can there be an individualized plan based on text messages? I mean, if we have a lot of text messages back and forth between students and allegations, would that be sufficient? Or do they need to have a hearing? Do they need to have testimony?
No, they do not need a hearing, and they do not need testimony for the emergency removal. If there is an actual individualized analysis that would show, for example, in this hypothetical, Judge Nowak, let's say that LG sent a text message that said, I can't believe you told on me, you caused our season to be canceled, watch your back. That would be an immediate threat of violence. We would concede that. That didn't happen. In fact, the only thing in the record that is before you is messages from the individual appellant saying, hey, I'm going to make sure none of this happens again. There's no confession. There's no admission. There's one text message from LG's mother that says, oh, I heard that my son wasn't involved in throwing the sneaker up on the scoreboard. Nothing about sex, nothing about anal penetration, nothing about touching of genitalia, nothing. None of that comes up until after, when the alleged victim writes in a statement that there was a dog pile, people jumped on me, somebody touched me. There were multiple references to other teammates. There was one reference to another child who I'm not sure how old he is, so I'm not going to mention his name, but he's not one of the named parties, but he's mentioned by name in the record.
At one point, don't we have the victim saying, I just want the conduct to stop?
Yes.
And then don't we also have an apology by one of the clients, one of your clients?
An apology for generalized allowing bullying to happen. Yes. Nothing about and that's why the policy is so important. It's got to be arising from allegations of sexual misconduct or sexual harassment. There's no reference at all to that because our boys never even knew that this was an allegation of sexual harassment or sexual anything until after the emergency removal. That was the first time we had ever heard that.
So do we have to wait? Are you saying that we have to wait for the acts of violence to repeat themselves again? Because they were not just a single one, wasn't it several acts?
Yes, there were allegations of 4 separate incidents of a dog.
So we need to, or not we, the people at the schools need to wait until there's another one to remove them? I mean,
No,
I'm just
Judge.
wondering how long we have to, these acts were different, happened on different days. They were surprises, so to speak, they didn't get planned or signaled. Like, why do we have to wait until another act occurs?
So, Judge, that's an excellent question. You wouldn't have to wait for another act to occur. What you need to have happen is an individualized analysis of the assessment that it's going to happen again. And there is never an individualized assessment that there was a threat that it would happen again. In fact, Judge, there's not even an individualized analysis that it happened at all. What we've got is approximately 2 weeks after the first incident, and this is the larger point that we raised tangentially in our brief. After we learned that the alleged victim was effectively cut from the team, he didn't make the cut, right? He wasn't going on to the federation.
Is there evidence on the record that the wrestlers in different weight classes, if one doesn't get to go, that one can go from another weight class?
That's correct. Yes, Judge.
I see. Okay.
And so the alleged victim was, I think, at the 282-pound weight class. Our boys were at 118 and 172. If there was a spot open, somebody else could slide in. And in fact, I do believe it's in the record that the alleged victim was, in fact, offered an opportunity to wrestle and declined right before the whole season was canceled. But in any event, the fact remains, and Judge Bannister, and I want to answer this question directly. And I got kids in school. I know where this is going. You don't want to wait for something bad to happen to protect the kid. But there was no analysis that there was a threat that something bad would happen. One of the 2 boys was in no classes with him and had no more season with him.
The other one only had 4 classes. We understand.
That's right. And by the way, the alleged victim himself he never claimed that he was afraid that this would happen again. He did tell one of the boys, LG, hey, that's fine. Okay, I understand you're going to tell him to stop. I just want this to end. At that point, we're all talking about, this dog pile. There's, pictures in the record. I'm sure you've seen them throwing my sneaker up on the scoreboard. Is any of that okay? None of that's okay. But do you remove them from the school and from all activities on an emergency basis such that
Okay,
you
again, we understand that. You made that point.
I have a different question. It's a little more of a practical situation. What does, if we were to reverse this, how would this affect any of the players in this?
Well, there's a couple of things. Number one is now our boys have graduated.
Right.
They've already been irreparably harmed. They've already lost their senior. They all lost that. But it's very important as a matter of, you saw the text messages, you saw the Facebook posts, you saw the rest of it. On the one hand, they would like to have that part of their, the besmirched nature of their name cleared. That's number one. Number two is, to the extent there's any record of this on their school files whatsoever, We want that removed. Now, the district spills a great deal of ink to suggest that this isn't discipline. Okay, technically it's not discipline. Technically, it's not a suspension, but that's why it's so important to do the individualized safety and risk analysis before you remove these kids, because it's not technically discipline. So you don't get to have a full tackle hearing. You don't. And so when we appeared, and this is all on the record, when we appeared with Dr. Croft, when we first got the notice of this, we weren't able to have any cross-examination. We weren't able to look at any documents. We weren't able to present anything. That was the very first time we had heard that this was of a sexual nature at all. So we were sort of hamstrung at that point. So circling back to answer your question directly, Judge, number one, it would do a great deal of help for their names to have that cleared. Number two is, to the extent there's anything on their record or there's a question that comes up, they're transferring into a different junior college. They're applying for a job. They're applying, hey, what happened with that Star Point case? Well, you know what? We got yanked out of class, but that decision was arbitrary and capricious, made by the school. And then Judge Caruso, who I happen to like very much, got it wrong. Wanted to stay out of it. There isn't even a written decision. He just said, no, I guess not. And you'll see that there's just been.
Yeah, no, I appreciate the answer.
So aside from not following the actual procedure.
Again, you gotta wrap up.
Sure.
Your time's up.
I'll just emphasize the word arbitrary here. We have all of these other kids are mentioned. The entire team is mentioned. There's at least 11 other people implicated. There are a couple of people named in this, in the record itself. None of them were removed from their classes when this first came up. Over the course of the last couple of months, a couple of names came in. There were some periods where a couple of kids got pulled here or there, but none of them got yanked or had their entire senior year removed. And so because we think that, number one, they didn't follow their own policy, and number two, the way they enforced that policy was by definition arbitrary. They only picked these two. We think that Judge Caruso respectfully got it wrong, and we think that Dr. Croft got it wrong.
Thank you.
Thanks, Your Honors.
Good morning, Your Honors. May it please the court, Ryan Smith on behalf of the defendant school district parties. School district has absolutely no interest in unnecessarily removing any student from its environment. But Title IX creates certain obligations, especially when they receive allegations of sexual assault between students. And the entire position of the district. I'm sorry, Your Honor?
Did they rush to judgment?
Your Honor, I don't believe that's a fair characterization of rushing to judgment, because even in the letters removing these students, it makes clear this is not a determination of guilt. This is not a disciplinary nature. It's an obligation to not act with deliberate indifference. And when a school district or any other entity that's governed by Title IX receives allegations of sexual assault between anyone under their control, they need to take whatever steps needed to immediately address the issue. And it's the nature of the allegations that warrants the removal.
Well, can you address the specific in your opponent saying that there was no safety and risk analysis, and that's required by Title IX and I think the district's own policies? What say you on that?
Absolutely, Your Honor. That argument was obviously addressed to the court below. It's been briefed, but let me just read one portion of the Department of Education commentary that specifically addresses that. The Department of Education specifically declined to prescribe procedures for emergency removals. And they say, we decline to require recipients to follow more prescriptive requirements to undertake an emergency removal, such as requiring that the assessment be based on objective evidence, current medical knowledge, or performed by a licensed evaluator. The department desires to leave as much flexibility as possible for recipients to address any immediate threat to the physical health or safety of any student or other individual. And I would also point out that the case of, I believe it's John Doe and the Superior Court of California, a case that the appellants have yet to address either below or on appeal, made the same exact argument. Hey, the school never showed us what this threat analysis was. And in that case, the kid actually signed something denying that he sexually assaulted the student. And that case went up to a number of state courts and went all the way to the US Supreme Court, and every single time denied in terms of requesting a stay of the emergency removal, because the allegations in and of themselves are sufficient to justify the emergency removal. The process was afforded to the appellants here. They were notified of what was going on. They were invited to challenge the decision. They challenged the decision. Neither student showed up to that meeting to challenge the decision, but they showed up and they presented nothing to indicate that they were not directly involved in these serious incidents involving this other student. And the standard here, Your Honors, is there a rational basis for what the district did here? And I submit to you that there is 100% a rational basis here. And even if this court were to say, well, there's a rational basis, but we might have seen it differently, respectfully, that's not enough. There needs to be more to even consider overturning what the lower court did here and agreeing with the district that these steps needed to be taken. We also assert in our papers that the preemption provision of Title IX preempts, precludes this entire proceeding, that using an Article 78 as a vehicle to challenge the process of implementing Title IX is not appropriate. There should have been a claim made in federal court challenging it and arguing that Title IX was violated. We tried to remove it because that's what we perceive this complaint to be. And the appellants asked to have it sent back, and it was. But Judge Villardo, in his decision, in fact, said that this preemption issue may well be dispositive of the entire case. And Judge Caruso, looking at everything that was presented to him, agreed with the district that it took the action that was rational, that was not deliberately indifferent, and that involved a really sensitive situation with a high school male student being sexually violated at wrestling practices. And it did what it felt needed to be done.
Thank you.
Thank you, Your Honor.